What happens when broken lives become billable hours? Good day and welcome to Silent Screams Loud Strength. I'm your host, Samantha. This is Unmasking Justice series. We have spent time exploring how systems can become fragmented, how information can be hidden or isolated, and how ability to participate effectively in a legal settings or legal proceedings can be impaired by circumstances beyond a person's control. We have seen how vulnerability, trauma, and the effects of abuse can leave people unable to engage in the way that the system expects, and how the gaps between different government bodies and the public records can create a space where the truth can be obscured. So today we move into an area that connects all of those issues together, and that reveal a dynamic that is reshaping how legal process works and who it serves. We move into what I call the economics of harm. The reality that when conflict generates income, delay becomes profitable, and the legal process can begin to function less likely like a system of justice and more like an industry. Okay, so when conflict generates income and delay becomes profitable, this is where legal process must be examined as an industry. For many people, when they enter family court proceedings, they do not do so with expectation that decisions will be made based on fairness and on the law and what is that right. They believe that the facts will become established, that assets will be properly accounted for, and that outcome will reflect the true position of all parties. But behind the formal structure, the rules, and the legal language, there is a very real economic reality. Legal services are provided by professionals who charge for their time. Every document that is drafted, every meeting that is held, every question that is raised, every argument that is advanced, every hearing that takes place generates fees. And when that is the case, there is a fundamental risk that runs through the entire system. When conflict continues, income continues. When proceedings are delayed or made more complex, revenue increases. So this creates a situation where the very system that is designed to resolve dispute can become a source of profit. And in cases, this dynamic is not just present, it is actively exploited. We are seeing a pattern emerge across many areas of legal practice, but particularly in family law. The financial proceedings where domestic abuse, coercive control, and financial abuse are not just matters of human suffering and legal concern. They can operate as a business model. We see cases where individuals appear to have no money in the court, claiming they are unable to meet their own needs, unable to pay debts, unable to make contributions towards the cause or the future of those involved. Yet when we look at records held elsewhere, such as Companies House, HMRC, and Revenue Customs, in company accounts, in financial statements, or in complex structures that have been created we find significant wealth, income, and assets that have been hidden, rerouted, or disguised. We see how legal teams can benefit directly from creating complexity where no genuine complexity actually exists. Cases that can be resolved clearly and efficiently are presented as involving intricate financial arrangements, multiple entities, hidden funds, offshore accounts, cryptocurrencies, or complex valuations. They raise detailed questions about where documents are not challenged. Every transaction and every issue raised extends to the analysis of the reports, and when the underlying facts are straightforward and simple to understand, we see how this deliberate creation of complexity generates high level of billing, extends the duration of the proceedings, and keeps revenue flowing month after month, year after year. This is not just a question of how much things cost or whether fees are reasonable. It is a fundamental conflict of interest that undermines the integrity of the entire legal system. It distorts the purpose of legal proceedings and the legal process. It disadvantages those who are most vulnerable, and it prevents the court from reaching fair, accurate, and just decisions. So today we'll examine exactly how this works, how it's structured, and how it interacts with the laws, principles, and standards, and that are meant to protect people, to ensure justice is done, not only just done, but seen to be done. We look at the alter ego companies, shadow ledgers, hidden assets, and the way the financial incentives can shape every stage of the proceedings. We will see how these arrangements connect to patterns of abuse and control, and we will look at the legal frameworks that exist to address these issues and the powers that are available to expose the truth and restore fairness. So, the dynamic when complex becomes profit. To understand how this operates, we must first understand how legal fees and costs work within the context of family proceedings. Under the Family Procedure Rules 2010, parties are generally responsible for their own legal costs, subject to the court's power to make orders that one party pays the costs of the other, or the costs are shared or adjusted according to the circumstances in the case. This means that costs can be substantial, and they can often be calculated based on the amount of time, effort that is spent working on the case. This structure creates a very direct link between the way a case is handled and the income that is generated. The more work that is done, the higher the fees. And the more complex the case appears to be, the more work is required. There's a clear financial incentive to create work, to extend work, to make the work appear more difficult or more complicated than it actually is. So the creation of complexity, we must make an important distinction here. There is complexity that is genuine, and there is complexity that is manufactured. Genuine complexity arises where there are truly intricate financial arrangements. This might include international business structures, assets held across different jurisdictions, complex trust arrangements, or financial affairs that have delayed or developed over time with many different layers and transactions. In these cases, the details needs to be analyzed, which is necessary, and the work that is required is proportionate to the facts in issue that are actually present before the court. But we see a very different picture emerging in many cases in the situation where there is no genuine complex issue or issues, where the underlying financial position is actually clear and straightforward. Cases are deliberately framed as complex. Parties and the legal team will present a narrative that involves multiple companies, hidden funds, offshore accounts, digital currencies, or obscure financial arrangements. They will arise as detailed questions about every single document, challenge every transaction, and require extensive analysis, reporting, and investigation, even when the facts are simple enough to be explained in clear terms. This is not about achieving a fair outcome. This is about generating fees, because every question that is answered, every report that is prepared, every hearing that is attended, and every document that is reviewed adds to the bill. And because fees are almost always calculated by the hour, the longer the case continues, the more work that is created, the greater the financial return for those involved. When proceedings are delayed, when issues are raised and then disputed and then raised again, and when every small point is turned into a major issue that requires further work, the revenue continues to flow, and the longer the process goes on, the more money is made. So the indicator, the broke in court, the wealth elsewhere narrative, one of the most telling signs of this dynamic is the contradiction that one sees so often between what is presented in the court and what is recorded elsewhere. We hear parties stand up in court and state that they have no money, that they are not able to pay their way, that they cannot meet their basic needs, and that they have no significant assets or income to contribute to the case or to the future of those involved. Yet, when we look at records held outside of the court process, we find a very different picture. We look at Companies House, we look at the records at Companies House, we find companies registered in their name or in the name of entities that are connected to them with significant share capital, assets, or turnovers. We find companies that are trading successfully, that have made substantial value, and that are generating regular income. Records at HMRC, we find declarations of income, profits, or gains that are much higher than those that have been disclosed in court. And on statements, we find tax records that show consistent revenue, financial activity, and levels of wealth that are not being reflected in the documents put before the courts. So, financial institutes and other systems. We find banks, bank accounts, investment properties, and transactions that have not been disclosed or examined. We find movements of money, purchases of assets, and financial arrangements that are not mentioned in the statements or evidence submitted to the court. This gap between what is said in the court and what the record actually says, the official records actually said, is not an accident. It is created through deliberate structuring, through careful selection of information that is shaped, and through arrangements that are designed to separate what is visible in the court from what is true in reality. And this pattern is very often closely linked to patterns of domestic abuse, coercive control, financial manipulation, and control. So legal professional incentives. This dynamic creates a profound conflict of interests that goes to the very heart of how the legal system is supposed to work. So legal representatives are bound by clear duties and standards. Under SRA standards and the regulations of solicitors are required to act in the best interest of their client, to provide a proper standard of service, to act with integrity, and to maintain public interest and confidence in their legal profession. Under the Bar Standards Board Code of Conduct, barristers have a similar obligation. They must act with independence, competence, and integrity, and must allow their own they must not allow their own interests or of others to affect their advice or representation they provide. Those duties are clear and unambiguous. But when the amount of work and the fees that are earned are directly linked to the complexity and duration of the case, there is a real risk that the incentive to generate work can override the duty to act in the client's best interest. When the people who are working on a case benefit financially from the case continuing from becoming more complex or from being delayed, there is a danger that they may be less inclined to bring matters to a fair and timely conclusion. They may be motivated to create or maintain uncertainty rather than to resolve issues clearly and effectively. They may be encouraged to raise points of dispute, to challenge documents, and to extend the process simply because that creates more work and more income. This is not just about a matter of cost or financial arrangements between lawyers and their clients. It is a serious threat to the administration of justice when the people who are meant to be helping to resolve disputes and to achieve a fair outcome have a financial incentive to keep disputes going. The whole system becomes distorted. It means that the process itself can become the product, and that the interests of the justice can be pushed aside in favor of financial gains. Okay, so the alter ego, the shadow ledgers, the structures become even more complex where hidden assets are not disclosed. To understand how these arrangements work, we need to look at the structures and the methods that are used to separate apparent ownership and the control from actual wealth and income. These structures are designed to create distance, to hide the true position, and to make it difficult to trace where funds come from and where they go. They are tools that are used to present one's picture to the court, to the tax authority, and to the public, while maintaining a very different reality behind the scenes. The alter ego companies. So one of those most common, most powerful tools is this scenario is that they use the alter ego companies. These are separate legal entities that are registered and presented as being independent, but which are in fact controlled by the same individual or group of persons that act as little or more than an extension of the person or group. Under the Companies Act 2006, every company is recognized as a separate legal person with its own rights, obligations, and identity. This is a fundamental principle of commercial companies law established to allow people to operate businesses, to manage risk, to conduct transactions with clarity and certainty. When used properly, this principle is essential to the functioning of the economy. It allows people to invest, to trade, and to operate with the knowledge that the actions of a company will not automatically make the owners or directors personally liable for all its debts and obligations. But this principle is not intended to be used as a shield to hide the truth or to avoid legal responsibilities. When companies are used to separate what is actually happening from what is visible, they can become an instrument of concealment. So in these cases, one company may be presented as having little or no value, income or assets. This might be the company that is supportedly involved in the family proceedings or in company that is named in documents as having only limited resources. But another company which is controlled by exactly the same person or group may hold all of the real assets and income, and the first company may be used to generate expenses, to show low profits, or to present a picture of financial difficulty, while the second company operates as the actual source of wealth and revenue. These arrangements create a clear separation between what is disclosed and what is true. And because each company is registered separately at Companies House with its own records, its own accounts, and its own details of directors and shareholders, it can be very difficult to see the connection between them unless all of the information is examined and cross-referenced and analyzed carefully. So without looking beyond the surface, it is easy to believe that they are completely separate and independent entities. So shadow ledgers and unrecorded transactions. Alongside formal records that are kept for official purposes, we often see the use of shadow ledgers or informal records that are not disclosed or registered elsewhere. These are assets of accounts or records that are kept separately from the formal financial statements that are submitted to HMRC, to Companies House, to any other official body. These records may show different figures, different transactions, or different levels of income and expenditure. They may be used to present one version of events to tax authorities and a complete different version to the court, or they may be used to record transactions that never appear in formal records at all. Transfers of money, purchases of assets, or arrangements that are never written down in a way that can be verified or traced. So under tax law, the company law, there is a clear requirement to keep accurate records and to disclose all relevant financial information. The Income Tax Act 2007 and the Commissioners for Revenue and Customs Act 2005 imposes strict duties on individuals and businesses to keep proper accounting records, to record their financial affairs accurately, and to provide information that is complete and truthful. It is an offense to provide false or misleading information to tax authorities or to fail to keep proper records that show the true financial position. But when shadow ledgers are used, it becomes possible to present a version of events that does not match the actual financial position. And because these records are not available to the court or other authorities, the truth can remain hidden, and the true position can be disguised or distorted. Hidden assets, these are new forms of wealth, new methods of concealment. As financial systems have evolved and become more complex, so has the methods that are used to hide assets and to make wealth less visible. Today, wealth can be held in all sorts of forms that are less obvious, less easily traced, and more difficult to verify than traditional bank accounts or physical property. We see it in several key areas where cryptocurrencies and digital assets, these are not easy. These are digital forms of value that operate independent of traditional banking systems. Transactions are recorded on public ledgers, but the identity of the owner is often protected by complex encryption and privacy measures. This makes it possible to hold significant value without the ownership being immediately obvious or easy to verify under the Financial Services and Markets Act 2000. And related regulations, these assets are subject to rules and regulations, but their nature by their nature means they can be used to hold and move value in ways that are not easily detected or traced. They can be transferred between accounts or converted into other forms of value without leaving a clear paper trail that can be followed or verified. Offshore accounts and structures, assets, and funds may be held in jurisdictions that have different legal and tax requirements, different reporting standards, and different rules about how information is shared with authorities in other countries. While many of these jurisdictions operate within international frameworks and standards, the differences that exist can create opportunities to hold assets in ways that are not easily accessible or visible to authorities in the UK. Under the Criminal Finances Act 2017 and international agreements such as common reporting standards, they are obligations to exchange information between countries. But these processes take time. They can require cooperation and they cannot be exploited to delay or prevent disclosure. So, intangible assets and hidden value. Wealth does not always have to be held in the form of money or physical property. It can also be held in forms that are not easily valued or identified. This includes intellectual property rights, licenses, interest in other entities, or other assets that generate value but are not easily recorded or disclosed. These assets can hold significant wealth, but if they are not properly documented or shared, they can remain hidden from view. All of these forms of wealth create unique challenges for legal proceedings because they are not easily visible, verifiable. They can be presented in conflicting ways. Their existence or value can be disputed, and because there is often a lack of clear information, they can create disparity and difficult to